that's the appropriate level to give. It's really when you get down to the detail of development.
So I do recall in your evidence you talked about the inappropriateness of potentially double dipping with those overlapping circles and the difficulties with, I think you termed it, a roaming open space zone.
Yeah.
But just going back to your points just then, if you determine it at the time of development, that is only this lot, and so again we come back to this issue of nexus. And if one is developing 100, I don't know how big this area is, 20 hectares of land, it's not reasonable to vest a large reserve when in reality this is the only place a reserve can go, and it is to serve the entire plan change area, yet there won't be an ability potentially to size it to an appropriate size to serve the entire plan change area, given that we'll only in the future be dealing with the subdivision of that highlighted lot, so that it wouldn't be reasonable to require something large enough to serve the number of residents in here at the time of subdivision of that lot. And so is it perhaps not appropriate at this point to say if there's only going to be one open space, that there is a need to have a minimum size potentially, given how many people will be living in here?
So I guess the first part of that question is there'll only be one open space. Well, the way that the provisions are structured and the way that the provision of open space works in the district plan currently is outlined in my evidence in chief, but also back in the request for information. So council negotiates it at the time of subdivision development. So this rule is really put in here as a concession to the applicant to say, we'll provide a piece of open space at the time of the subdivision of lot 59465292, but that doesn't say that there will be no other open space provided throughout the rest of the site or centrally in the residentially zoned land. There's sufficient scope and ability, in my view, for council and a developer to negotiate that at the time of subdivision through the existing provisions that apply, and that's how it's consistently done in the Whangarei district plan. So
I think it's a little bit different here though, because I again it impeded by not having dimensions or sizes here, but there's already a significant subdivision pattern there, and if they were to be developed one at a time, unlike the rest of the plan, that there are larger greenfield sites that have been developed, so it is quite a different circumstance.
Yeah, I think you do have sites, but the majority of them, as I say, are owned by one developer or two developers. And I've just looking at when you step through the existing provisions, I do see there to be a clear pathway to provide open space at the time of subdivision development. And you always get, in my view, into the trap of going, well, how much now? How much do we provide now based on what we're zoning, and oversupplying it or potentially undersupplying it? And in my view, that is best determined at the time of subdivision and development.
Can I just got a little break, just go back to one of the other points that was raised earlier, which was in terms of where on the site this would be. But the matter of discretion includes the design and location of the reserve, including access. So when you're applying for your RDA consent, that's one of the matters that is subject to the discretion. So that's just an aspect in terms of this significant area that's required by this rule. And obviously, Mr. Bantham's explained the broader context in terms of other locations where in this broader area you would also have reserves. But I do think this does give the council an ability. First of all, it identifies the block in which this more major or more significant reserve would be. Secondly, it gives an assurance that you're going to have about two site boundaries directly joining a road, so you have something that isn't hidden behind people's properties, a la 1960s Mount Albert crime at the moment, where there's a whole lot of very bad planning done. You do have reserves that are facing the public spaces. One of those needs to be the northern side, so you've got light coming into it. and you have this ability for council to exercise discretion in terms of the design and location. So the intent here is to give council some pretty significant discretion in the context of a consent application for the reserve that's required. So I think, Commissioner, you're muted.
Sorry, there was every so often I turn it off because there's noise outside, and then promptly forget I've turned it off. So, Mr. Badham, you mentioned earlier, picking up that point that Mr. Allen's just made, that it has to be located within the residential part of that land, but lot 59 DP 465292 is the whole thing. I'm just trying to work out where the. Oh, sorry, it's in one. Yeah, I see. Within the general residential zone of. Fine.
Yeah, it was just the lot was identified originally by Ms. Ryan in the Section 42A report. There was a section discussing the provision of open space in that lot. We didn't have track change version of the provisions at that time, so I didn't, in my evidence in chief, I didn't have the opportunity to actually understand what the intention was from Ms. Ryan. So this, when developing this rule, was in discussion with Mr. Burgoyne and Ms. Ryan about, well, actually there is an opportunity to provide, given the size of this lot and it's in single ownership, an area of open space. So it was identified as well, it is pragmatic to put an area of open space within that lot at the time of subdivision. We have got complete control over, if you will. And then, in my view, the rest of the site is there to go through the standard process for the provision of open space at the time of development. That's how I've considered the matter. And then separate to this, we also have accepted an open space provision in the Marsden Town Centre zone, which was actually outlined in Mr. Riley's evidence, which has been incorporated, but that's separate to this. I'm talking about the precinct for now.
So just a follow-up question. Earlier today we talked about transition effects with Mr. Riley between zones, and Mr. Burgoyne pointed out the commercial zone has rules about height to boundary next to open space. Is there a need to have, given that it won't be zoned until later, so if we have this rule and then the open space is vested, there'll need to be a plan change to rezone it so that commercial, if it did end up being next to the commercial zone, it wouldn't have the protection of that height to boundary rule to prevent shading of the open space. I can see Mr. Burgoyne has his hand up.
Yes,
perhaps
that's right.
to clarify.
Should we go to him first and then?
Happy to.
Oh.
Sorry, yeah, just
just
to help out with that one. So those rules in the commercial zone that do link back to different setbacks and height in relation to boundary and landscaping and stuff next to general residential and open space, they apply consistently to both general res and open space. So for that particular issue, those same cross-boundary rules would apply whether or not that site is colored in yellow or green on the planning zone maps. They would have the same suite of rules. But yeah, at a higher level, I guess, as part of a future plan change, if we did have open space reserves, particularly ones that are vested in district council, we would be looking at rezoning those as open space. And that's what we've just done through the open space plan change.
The other thing I would add to that as well is that we're looking in the consenting framework too. So this is restricted discretionary for this role. And you could look, depending on where you're located, you could also put consent conditions if you needed to. The concern I had about the infrastructure provision and the evidence of Ms. Brownie in terms of the second rule, which related to sort of applying a roving zone, was that you would not know where the zone was to apply. At least through this way, it would be through a consenting framework. You would get the open space, and then in the future, yes, it would be rezoned in the next catch-up or the next version of the urban and services plan changes that council does in 10 years' time. That's just sort of the nature of how open space seems to work. It's provided at the time of subdivision, and then council has to catch up and rezone it once it's theirs at a later date.
Thank you.
Was there anything more from you on that, Commissioner Dimery?
Not on that
No,
particular
okay.
rule, thank
Yeah, no. Now I'm happy we move on to the next.
The next one is just to do with the landscaping rule that Mr. Riley was questioned on earlier today. So, as outlined in my rebuttal, it's been combined into one rule just because it seemed more efficient in my view to have it as one precinct rule rather than in the separate precincts. And that's the requirement of not less than 2 metres depth landscaping. So we've obviously spoken about this earlier, but it's whether you have any additional questions for me on this rule.
I don't. Do you, Commissioner Dimo?
My only question was just, I appreciate that the sites would be constrained because they've effectively got 2 frontages, so that, but by the same token, I did wonder with 2 metres in depth if that's actually sufficient to get a mature tree with a canopy spread that Mr. Riley's envisaging. It seems fairly narrow, but that's just a comment, I suppose. I do appreciate that there's a landscaping strip required on both sides, but it did seem that whether the intention will be able to be delivered, or whether it may end up being a dense vegetated hedge screen that Mr. Riley didn't envisage. It's not clear to me there.
Look, I've relied on Mr. Riley in terms of the depth. In my view, the rule can work in terms of that interface because it's a combination of trees, shrubs, and ground cover. I took the point that there was a concern that you could essentially get someone just putting a grass strip, a 2 metre grass strip along that boundary. But I read the combination of trees, shrubs, and ground cover to give you that. And now, look, with these sorts of rules, you can always be. There's always a spectrum, like I said earlier, of prescriptive versus flexibility. You could get very prescriptive and say that the trees had to be spaced not less than 1 metre apart. You could say they had to be to a mature height of 2 metres. We could look at that stuff, but in my view, I think this is. I like to keep the provisions as simple as possible, and I think this is clear.
Sorry to interject. Would you mind if I just added just a kind of a confirmation comment to what Mr. Badham is saying there, if that's considered appropriate?
No, by all means.
Thank you. I think it is, as Mr. Badham is commenting, I think it is a question of, along that spectrum. I think something to consider also is that, in a sense, along One Tree Point Road and along State Highway 15, there will be some berm along that particular area as well. I'm aware, of course, you kind of, in a way, kind of stealing or borrowing perhaps space from that kind of, legal carriageway, but the carriageway itself won't be built exactly to, to the boundary. So there will be some space in a way to kind of borrow from. And it is a question of, would 3 meters be more appropriate? Yes, 3 meters would allow a more generous tree canopy spread. But I think, again, when you do look at all those various aspects of both the canopy of the tree, mid-height shrubs and low-height ground cover, combined with, will buildings be built all directly to the rear, up against a landscaping strip? I wonder on balance. I think there's probably a reasonable probability that they won't. So yes, there is a risk element, but it's a question of where do you fall in there. 3 would be generous. 3 meters, I think, would be generous. I think 2 is sufficient given that context and given the ability to, in inverted commas, borrow a bit of space from the carriageway side of the roads.
Thank you for clarifying that. I just have a couple of further questions, probably best for Mr. Badham. And looking at the matters of discretion there, is it necessary to have outlook and privacy of adjacent properties if the intention is I'm just trying to balance here, getting appropriate matters of discretion to for the purpose that, as Mr. O'Reilly and yourself have articulated this rule, and it seems to me it's more about an attractive frontage for passers-by, breaking up the mass of the buildings, but as opposed to privacy or anything like that. And I don't know that again, shading and dominance.
In terms of the issues, yeah.
Size of the vegetation, and I do wonder if there should be some discretion if we don't stipulate it. I accept what you're saying, prescribing spacings or from centres is over the top, but could there be a matter of discretion over? There should at least be a matter of discretion over the nature and scale of proposed vegetation.
Like I think in short, we'd used from memory some of the matters of discretion from a similar landscaping rule in the COM zone, but I'm happy to revisit those matters of discretion. I think you make a good point, especially about that first one.
It did sound like the intention of the rule is more about how it presents for passers-by as opposed to creating amenity in a street in a lower speed environment, like you might see in the commercial parts of other parts of Whangarei. So it's quite a different context here, and it does seem that matters of discretion could be fine-tuned.
I agree, and I don't think they necessarily pick up that that point that came up in the early discussion, which is sort of breaking up the form of the development behind, not necessarily screening, but breaking it up. So it seems to me that sort of streetscape character and amenity sort of picks up some of the issues we discussed earlier, but perhaps not as fully as it could. But the other ones don't really necessarily sit, 1, 3 and 4 don't really seem necessarily relevant to what we're seeking to achieve.
Okay, I've highlighted it on the screen. I'll come back to that.
No, thank you.
Look, now we're into the to the sub precincts. So essentially clarified that the underlying provisions apply unless they're superseded by the provisions below. So for the mixed use zone, there's only 2 provisions, and really they're both related. So the way that the Whangarei District Plan works is you have a provision about minor buildings at the start of the chapter, and this Rule 8 is included to clarify that in terms of Rule 10 below. And this is essentially the setbacks that are slightly different from what's in the underlying zone.
Mm-hmm.
And that's mainly around not applying to One Tree Road boundary. In the medium density residential zone, it's intended that the underlying provisions apply in their entirety. There's no exceptions in that sub-precinct. The general residential zone only has one bespoke provision relating to retirement villages, and that's just to, I think in the underlying environment, the difference is that it's discretionary. We've changed it to restricted discretionary, given the location of the retirement villages we've already got. Well, we've already got one and there's a second stage planned. Commercial south. No, actually this, I'll mention this again when I go back to my statement, but these are the rules that I inadvertently deleted based on Mr. Riley's evidence. There was in the underlying commercial zone, there's a clause 1 to this rule, which is a 50%, I think 50% coverage within 1 metre, which Mr. Riley in his rebuttal, potentially evidence in chief, his evidence in chief, not his rebuttal, had addressed and said that it should remain. So I'd inadvertently, through the Kāinga order, consent order, deleted that. I've reinserted that back in here, so that still applies. There is also building frontages. Again, there was for the glazing requirement in the commercial zone, to clarify that the 25% building frontage glazer does not apply at the One Tree Point and State Highway 15 frontages, given the interface there. And the last rule is just the visitor accommodation, saying that it's discretionary, but then adding an additional element that if visitor accommodation is on a site adjoining the State Highway 15, it actually becomes non-compliant. Just to cover that. And then in the commercial precinct F, the same provision around building frontages that applies. I'll have to double back to that because I think I've actually slightly missed one, which is again the rule which applies in the other commercial zone. But you have two rules there. Then we're into the information requirements and maps. So I don't know if you had any questions on those.
Sorry, is this a different version you're looking at to what we got circulated? I don't seem to have that rule previously.
Yeah,
this one.
This is different to what we got a couple of days ago.
Yes.
So I recirculated in the email I sent you this afternoon. I had updated in the attachments. You'll see that I've been talking to a summary statement, but there's also a summary statement with attachments. But
That's
if I go,
I thought I wrote it. It's dated 21st of October.
So I've sent you another one dated 27th of October.
Oh, okay. Sorry.
And the only difference is the provisions that I inadvertently deleted from the consent order. So
okay,
it should be in
you.
the latest version I've sent through.
Okay.
Are you back on screen, am I? At this point, I just plan to go back to my summary statement and just work my way through that again. Okay. Oh, no, sorry. That's the wrong version. Too many documents open. That's the one. There we go. So I'm just now touching on some of the high points in my rebuttal and just my response to some of the pre-circulated evidence statements. In reality, we've already kind of talked through some of these issues when we went through the provisions, so I won't dwell on them for too long. Just relating to the Council Infrastructure and Services Department for Wastewater, there's been a discussion with Mr. Allen this morning in the legal subs, but also questioning of Mr. Bellingham. I thought it would be useful if I just highlighted some of my views on this. And what I also thought would be useful is if I actually brought up, I'll talk through this, but then at the end I'll bring up a copy of the actual Three Waters Management Chapter view to reinforce what I'm saying. So look, at 3.2, I'm just making the point that there is an acknowledged capacity constraint in the existing treatment and disposal facilities in the Ruakaka and Marsden Point catchment. This applies to the entirety of the catchment and future development areas within it, and not just the Marsden City land. And look, this has been acknowledged in the Maven infrastructure report, the evidence of Messrs. Campbell, Charles, and Bellingham. No one's saying anything different to that, in my view, in terms of the expert evidence. An upgrade is required to cater for future wastewater connections in the future. The applicant acknowledges this, and Council has identified and provided funding for a suite of projects to provide additional network capacity, and that's canvassed in the further evidence of Mr. Charles. Really, my rebuttal evidence focused on the evidence of Ms. Heather Osborne, who recommends bespoke precinct provisions relating to wastewater. In my opinion, it is unnecessary to include those provisions because the Three Waters Management Chapter has TWM Rule 3, which provides a recently scrutinised and accepted approach to the management of wastewater, which is applied consistently district-wide, providing an additional rule, matter of discretion and information requirement in the manner outlined by Ms. Osborne is neither efficient nor effective, in my opinion, and will result in confusion and inconsistent application of the Whangarei District Plan. At B, I'm just again highlighting a point that Mr. Allen made earlier, which is that there's no characteristics of the Marsden City land, in my view, that differentiate it from land in the wider Ruakaka Marsden catchment or within the wider district with regard to wastewater infrastructure. In my view, Council has sufficient discretion within TWM Rule 3 to consider and, if necessary, decline resource consent applications if an applicant cannot demonstrate sufficient capacity exists. And at this point, I will bring up a copy of the rule to work through. So is the web page shown on your screen?
It is, yeah.
Yes.
Yeah. Perfect.
Thank you.
So this is the provision as it relates to wastewater. So essentially, all subdivision in the Whangarei district now is restricted discretionary. It used to be controlled, but this is a new provision that's come in and recently settled through the consent order, and it requires that all allotments are designed and located for provision of collection, treatment and disposal of wastewater in connection to a public reticulated wastewater network, where the allotment is within a reticulated wastewater area, which Marsden City is within a reticulated wastewater area. The matters of discretion are listed in 1 to 6, but they're quite broad. Adverse effects on existing reticulated wastewater networks. I think this point 2 is quite key. The capacity of existing reticulated wastewater networks and whether the servicing needs of the proposal require upgrades to existing infrastructure. And then there's a number of other matters there which I won't go through, but I think that point 2 is quite key. And then it just talks about how there's acceptable means of compliance in the design and construction within the engineering standards. Another key component of the rule is the notification rule. It's non-notified. So any application is non-notified unless the network utility operator, which would be the council, could be limited notified, or there's special circumstances which exist under the RMA. So in my view, that's a pretty robust framework for council to consider wastewater infrastructure. I've looked carefully at the evidence of Ms. Osborne and what she suggested in her option, and I can't see the basis for having additional requirements for Marsden City land when you compare that to what's happening in the rest of the catchment, which has also been subject to rezoning recently as well. I'm just sure this goes. And look, then that last point in C, I just say that I don't think there's any basis for a different notification test, because one of the recommendations from Ms. Osborne was that it should be subject to the normal notification test. So I think there should be consistency in that as well. Moving on to the Parks Department submission.
Mr. Badham, could I just interrupt and ask a few questions, please?
Yes, of course.
Yeah. So what you're essentially saying is the entire catchment does have capacity constraints, so it's really going to be a first come, first serve. So it could be that some development goes forward up at One Tree Point and some happens down at Marsden City, and at some point when the capacity is reached, there's a potential that consents may be declined, and in your view that rule is sufficient to allow consideration. So perhaps I need not worry that houses may be built but can't be connected to a network. So that's your view, that we rely on the district-wide rule, and as the development progresses, that rule enables consideration of the capacity, and trustfully the infrastructure department will be progressing upgrading plans.
In a nutshell, yes, that's my position. Is if we didn't have that rule, I think, in my view, there would be some concern if you were under the old version of the plan where this matter was not really well considered. I think the new rule and also the associated objectives and policies within the Three Waters Management Chapter are quite strong, and it provides council the discretion and ability to slow down development if the infrastructure is not there. In reality, infrastructure and development and zoning, it's not a chicken and egg necessarily. Some people will be of the view that the infrastructure must be completely there before you can rezone land, but that's not in reality how it happens. The two sort of move up as they're provided, and also, as you don't forget, as you develop land, council takes development contributions which it can then input back into the infrastructure. And from my understanding, council might correct me if I'm wrong here, I think it's about $10,000 for wastewater contributions for Huey's in Ruakaka. So yes, I'm confident and comfortable that there is an ability for council to stop development if there's not sufficient capacity for it to be serviced.
So your point not to labour it perhaps, is that if there was one of these other options looked at, it might have the impact of reserving capacity for development that's still not consented or happened, just because there's an ability to in this plan change area, whereas what you're saying is that development will happen and who knows what order it will happen in and where it will happen first, but that there is an ability when it reaches that point, if the infrastructure isn't in place and the capacity issue remains, that whoever the unlucky one is that comes along at that point may be declined or held up. But you don't see it as efficient to have a constraint placed on just this plan change land because it applies across the whole catchment. Is that a fair?
Yes, it is. This is not unique. The whole catchment has this issue, and council has recently rezoned, as you'd have been involved in, for the urban services plan changes, significant areas to the north of this for residential land. As you can see with development, looking 10 years back from the Marsden Primary Centre, things change. We had a global financial crisis back in 2010, which really slowed down Marsden Primary Centre. So things change and you don't know which one's going to come first. The key message is that council has the ability to say, well, we're at capacity, there needs to be something else. And from my understanding and reading of the evidence, is there's a number of options that can be done to increase capacity, be that longer term the ocean outfall, but also from the Maven infrastructure report, there's more localised solutions that you could come in terms of localised treatment tanks or holding tanks.
I mean, this might be more of a question for the infrastructure department, but my understanding, which appears to be incorrect from the urban and services plan change, was that there was sufficient capacity for that zoned land. And I recall that there were some areas, I can't remember that, I think it was a pie land, that was proposed for on-site wastewater. So I presumed that was to address the capacity issues, and I presumed that there was sufficient capacity in this whole catchment, but perhaps it sounds like that's something for me to explore with the infrastructure.
I think I'd also add to that, though, that there were some, as I understand it, some site-specific solutions developed probably in advance of resolution of the general rule relating to wastewater, so that if somebody if somebody was proposing a rezoning through the urban and services plan change, they wanted to get on with it, and they're prepared to go to the council and say, we'll do a site-specific solution for this. Some of those may have appeared in consent documents, but that the general rule has been now resolved through a general consent arrangement that applies across the district, and it applies throughout sites here that are not subject to site-specific constraints, so or site-specific solutions. So I think the important thing is that under the plan as it is now, council reserves the right to say no to a development. Now, what more can it possibly want than that right on this issue? Ideally, of course, the rate at which DCs come in, development contributions come in, and the ability of council to consent what it needs to build, knowing, looking from here, and in fact looking for several years in the past, it's going to need to do something else, and its ability to actually construct that will coincide, so that we won't get to a point where any development is actually stopped, because that would be an unfortunate outcome for an area that the council wants to develop, and that has an opportunity to become quite a coherent whole once all those bits in between do develop. But this mechanism at least says that if there's an issue with wastewater catchment, wastewater capacity, council has an ability to say no to it, should it need.
Thank you.
Right, I'll move on to the Parks Department. Look, I appreciate we've just had quite a long conversation about that, so I'll scoot through this one a little bit quicker. Essentially, I'll go to paragraph 3.7 and just say that I've maintained my position in my evidence in chief that the provision of open space is best determined at the time of subdivision. On top of the inclusion of policy MCP P10, I have outlined two further rules in paragraph 3.11 of my rebuttal it should say, for the provision of open space at the time of subdivision in the town centre zone and in lot 59 DP 465892. I consider that no further changes are required in response to the submission. I just wanted to touch briefly on Kiwi Rail. Again, there was quite a robust discussion with Mr. Allen this morning in the legal submissions, but at 3.8 there, I just highlight that Kiwi Rail have maintained their position of vibration controls that should be applied. And I just highlight the key point that they haven't actually provided any technical evidence in the context of PC 150 to justify why these provisions should be included and why the Marsden City land is uniquely susceptible to vibration. So similar to what Mr. Allen's said there, and highlighting that this is subject to a district-wide appeal. A number of parties have referenced that. I'm involved in the mediation too, but it's all subject to confidentiality without prejudice. So there's only so much we can say, but it's ultimately being looked at on a district-wide basis, and the applicant is a party to that, as a 274 party to that, on the basis of consistency between what happens in the district-wide sense and what happens to this land. So I think ultimately the outcome will be borne out in the consideration of the appeal on the urban and services plan changes, rather than prematurely trying to apply ad hoc provisions to Marsden City, which may predetermine what happens there. That's essentially where I got to with vibration. Regarding Waka Kotahi, Mr. Ormston's already, well, in his rebuttal, he's addressed the evidence of Graham Norman. Again, I provided quite a comprehensive response to the evidence of Ms. Thompson. I haven't proposed to go through that in any detail, just to highlight the high level that I think the zoning change for the low density residential zone to commercial zone will address some of the key concerns Waka Kotahi has in terms of reverse sensitivity. With regard to the other matters raised by Ms. Thompson, I'm satisfied that these are adequately addressed by the applicant's evidence and analysis, and no further amendments are required in my opinion. Just touching on refining New Zealand's submission, and I guess the concept of reverse sensitivity in general. Before I go on to 3.12, in my view, the applicant's approach to reverse sensitivity has been robust. Mr. Ibbotson's evidence regarding, I guess there's two scales you look at it. You look at it in the micro scale of the land with the location of State Highway 15 to the east and the rail spur to the north. Those are the two really adjacent noisy activities, if you were, that could relate in reverse sensitivity effects, and that's been comprehensively addressed by zoning, so a buffer of commercial zone around the proximity of the site, and then further by the noise zone overlays that Mr. Ibbotson took you through earlier today. There's a lot of conservatism, in my view, built into that, 70 metres, and then also the zoning extent is 100 approximately, as per the dimensions that Mr. Ibbotson done. So I have a high level of comfort that reverse sensitivity effects in those locations are avoided, relying on the evidence of Mr. Ibbotson relating to noise. What I'm really addressing here is paragraph 3.3 I mentioned earlier. I've accepted Mr. Macefield's evidence relating to the term avoid in terms of manage in order to give effect to the regional policy statement. As I mentioned at 3.14, Mr. Ibbotson's addressed the noise component of Refining New Zealand's submission and evidence and concluded that there's no reverse sensitivity effect generated. And I think he uses the term, there's no credible way that you could say that the noise from the refinery is going to be excessive on the site or something along those lines. The next point is really, I guess the key thrust of the refinery's case is around air quality, and I'm a planner, I'm not pretending to be an air quality expert. I just found when I was reading Mr. Chilton's evidence, there was a couple of issues I identified and addressed in my rebuttal, but also in my rebuttal statement, I provided some context around zoning around Marsden's or around the Ruakaka Peninsula. And what you can see from Mr. Chilton's evidence is that the majority of complaints are coming to the north and east at Ruatahi, which is where seems to be the wind is taking the complaints, but that's also where the closest receivers are. There was very limited complaints in the direction of Marsden City, And notwithstanding what Mr. Allen spoke about this morning about how do you get to the threshold of a reverse sensitivity effect that needs to be avoided, I share that view. I don't think necessarily several complaints over the course of 5 years represents a reverse sensitivity effect. And yeah, you've already got a whole multitude of areas that have been recently rezoned, notwithstanding the area to the north and One Tree Point for residential zoned land, which would have no complaints covenant applying to it, and it's closer and it looks to have more prevalence of complaints. So looking at that in the round, I don't consider that Mr. Chilton's evidence justifies the conclusion that there's an odour reverse sensitivity effect that needs to be avoided by the application of a no complaints covenant provision. In my opinion, any agreement to include such covenants would be a private agreement between the developer, or the eventual developer, and Refining NZ. At point 4, I've just outlined again some of the corrections that I've already discussed. So the zoning and precinct maps at 4.2, which I went through in my presentation, they're attached in the version with attachments. And then also just acknowledging when deleting provisions, I appreciate with the amount of colours and changes in versions that things have been a little bit complicated. And look, I'm putting my hand up, there might be still some ones that I pick up, but I'll keep identifying them as I do. And I've just talked about those provisions that I identified earlier when I went through the precinct. Just clarifying as well at 4.4, no further changes have been made to the town centre, Marsden town centre zone provisions from my rebuttal. And I've also reattached the most recent versions of both the trapped and clean provisions of the precinct and the Marsden town centre zone. And I've also reattached copies of the consequential amendments. So you've got them all, you should have them all in one place. So the consequential amendments are to the noise and vibration chapter. The one thing that I've done in that attachment is Mr. Ibbotson has tracked them on the appeals version. We had done them originally on the operative version, but thought for ease of reference in terms of the zone names, we've used the appeals version, so it makes more sense. And then we also have the changes, and the attachment 8, urban form and development, and attachment 9, additional consequential changes, are the same as what I had attached in an annexure to my evidence in chief. I've just reattached them in one place. And finally, just to my conclusion, so overall, after carefully considering the relevant statutory documents, the submissions and further submissions received, assessment undertaken in the Section 42A report, and submitted evidence received, I continue to recommend that the plan change be approved with modifications as I've outlined. That's all I had planned to talk through, but I'm happy to take any further questions you may have.
Mr. Dimmery, do you have further questions?
I'll just take a moment to just refer to my notes on the evidence in chief. And
I have a couple. Shall I go first?
Yes, sounds good.
I appreciate that you've identified that the structure plan is now quite old. What did the structure plan show for the area relative to what we're having forward in coming forward in the plan change? Was the structure plan more, or was the current provisions more aligned with the structure plan, or sort of how far are we deviating from it?
So the structure plan has a map at the end, which is a larger area of land, or the whole Ruakaka area, Ruakaka Marsden Point area, and it has zoning for that entire area. In terms of the subject site, it does show a town centre or centre of some sorts, which looks significantly bigger than what we have put in. So in a sense, we have reduced the size of the town centre, as Mr. Heath identified earlier, to make it more viable from an economics perspective. And the other changes around residential, so anticipating residential land around it to support the town centre essentially.
So did the structure plan have any residential shown, or was it a centre with retail surrounded by commercial? Or
it's a centre which is surrounded by mixed use, a large area of mixed use and industrial land to the south and east, and then further residential land primarily to the north.
Is it possible to put that on the screen, perhaps, Mr. Adam, just to
think Rob might have done that for me.
Yes, he's ahead of me.
Sorry, Mr.
Okay. Although I'm not seeing it yet, is every...
There we go.
Good.
Oh, relatively accurate. So again, this is 2009, I think it was adopted. 2008, possibly.
Yep.
So quite some time ago.
Okay, yeah, so very different in terms of the size of the primary centre.
Yes, so you can see that hatched is identified in the structure plan map as primary centre, which is an excessively large area of land in my view. And then to the north you have residential, but then it shows you also different land to the south as well. Okay,
yeah, no, fine, thank you. That was just a more point of interest really, because I do recognise it is old. And then I did have another question, which was you talk about no, what am I looking at? I think I'm looking at your evidence in chief, 8.4, where you're talking about the MPS UD. Don't know if you have that in front of you yet.
Yes, I do.
Martin, yeah, okay, so 8.4A.1, and you talk about enabling the provision of a variety of housing typologies that meet the needs of different households. I mean, I think realistically within the general residential area, do you expect to see anything other than standalone houses in this location?
So the general residential zone, as it's operative in the Kainga Consent Order, generally is sort of the, I guess, the equivalent if you're in Auckland in single house zone. But then there's also provision for multi-unit development in the provisions there. So it allows for 3 or more dwellings to be done as a multi-unit development. Where I was envisaging housing typology difference is also in the medium density residential zone, which allows you to go down to a lot more denser development in terms of allotment size and density. Well, I don't think there is a density requirement actually in the medium density.
That was it for me as specific questions, because we've run through a lot on the way through anyway. Commissioner Dimery, did you find any unanswered questions?
I did have some questions we touched on this morning. I haven't had the chance to read Ms. Shaw's legal submissions, and you did tell us that there was some disagreement whether the changes you've suggested to the urban form and development chapter could be undertaken. What is your alternative, depending on the outcome of what we hear from Ms. Shaw, if it's not open to alter the urban form and development chapter? Do you have a suggestion of what your alternative would be?
So subject to your determination on that, based on the legal submissions, I think there is an alternative pathway forward where you incorporate essentially the same component in the precinct. It's not ideal from a planning perspective, in my opinion. It would be better for the architecture of the plan if it was in that chapter. However, as we are in a rolling review process with plan changes being considered, it's somewhat symptomatic of a rolling review. So, yeah, in my view, if there was a determination that you couldn't change the urban form and development chapter, then I think you could essentially make the similar policies in the precinct would be the place I would put it.
Okay, thank you.
And can I just add that Ms. Shaw made a fleeting appearance on the screen just a minute ago, and she, I think, presents after us. So yeah. I had a little look at that very brief part of her submission. She's suggesting that you could locate the new policy, and this really comes down to one policy, I think, and there's a couple of other consequential changes. Locate the new policy in the Marsden Town Centre Zone chapter, and the council could relocate the new policy, or recommend that the council relocate that when it's able to, and it does its next plan change mechanism. Look, I'm happy to defer to Ms. Shaw's far more encyclopedic understanding of all the appeals and all the consent orders and all the other decisions that have been made in the context of the urban and services plan changes. Ideally, we would say you end up with saying things once in the plan and just cross-referencing to it rather than having it said twice. If we need to say it twice for technical reasons at this stage, then we do it. But ideally you'd fix that up as soon as you could, and that's a matter for council as opposed to yourselves. But we'll defer to Ms. Shaw's judgment on the mechanism for dealing with those matters. Which we'll soon hear from her, I'm sure.
Yeah. Thank you. I think we've possibly covered most things as we went through the provisions. I did have in mind a recollection from the 42A from Ms. Ryan, some disagreement about the name of the zone. I mean, did you have a view on that?
Yeah, I covered that in my evidence in chief. I'm just going to find it. I essentially, I don't see it as a fundamental issue in terms of the zoning name. I had recommended, and the application was for a special purpose zone. I understand Ms. Ryan in the 42A report is saying that it should be a town centre zone, which could then be used elsewhere in the district as well. So rather than being a special purpose zone, it would be a town centre zone. In my view, there's sufficient justification there to make it a special purpose zone. However, ultimately, if you were to change it from Marsden town centre zone to the town centre zone, I don't see that as being a fundamental issue. I addressed that in 11.2 to 11.2 and 11.3 of my evidence. Evidence in chief.
Thank you. Thank you. It was just a small matter that just stuck in my mind. I think we've probably covered most things. Thank you. I do think, like I've said a couple of times, it would be useful to have a plan with some dimensions to just understand how these provisions might be applied. One thing I've got a note on is trying to understand, given the size of the existing lots and where it will be general residential, where there's a potential that you'll end up creating a lot of rear sites, whilst there's an indicative road plan shown there with north-south street alignment network, which can be considered under that rule. Is there a potential that alternatively these existing sites could all just have joint owned access lots, and that would be quite a different outcome? And is there anything that would prevent that or allow that to be considered?
So I guess in the first part we can get you a map with dimensions. I suggest is it just the block? You want to see the block dimensions for the main blocks, or?
Yeah, it would be useful to just understand the size of some of the existing lots and the dimensions for how deep some of the precincts are, because as that discussion with Mr. Ibbotson showed, it was hard to know how much of that residential hangs over into that that noise area.
Yeah, I appreciate it can be quite deceptive when you look at the subdivision pattern and allotments. They're actually quite large because they've been subdivided on an industrial basis by the previous owner of the site.
That's what I mentioned. Yeah.
I want to say, and Mr. Burgoyne may interrupt me here in terms of subdivision, but I understand there are provisions around subdividing rear lots and managing jointly owned access lots. So notwithstanding the indicative roading network plan, you also have provisions in subdivision that apply to the general residential zone, understand? But I'd have to come back to you. I can't really bring them up right now.
Yeah,
I would to understand that.
So those lots, as you say, they're divided at a industrial scale. So each of those lots would trigger a subdivision consent to development for housing. So that would come in via that route.
Essentially, that's what I'm saying. Yes.
Yeah. Okay.
But there is a discretion to consider the appropriateness of rear lots, as opposed to if that was proposed as an alternative to what is shown in the urban design concept. Yeah. that's all from me. Thank you.
Yeah, so no more from me. Thank you, Mr. Badham. So, yeah, thanks for your time. We've kept you a long time.
Thank you, sir. That is the last of our witnesses. So that's the end of our opening case. And,
thank you.
We can pass over, I presume, to Ms. Shaw to tell us council's view on the law.
Yes, so Ms. Shaw, sorry we're running late. I presume you're all okay for time still?
Yes, good afternoon.
Oh, you're very faint actually. I can barely hear you.
Is that better?
It's still quite faint. I'm happy to turn my sound up, but are other people all okay? I can't hear you at all now.
Yeah.
Any better?
No, still very faint.
I can hear you, but you're very quiet.
Just checking if there's a setting.
Is there a different speaker, maybe?
It's almost like it's picking you up from the computer. As you got closer, it seemed to get slightly louder.
I'll try again without the headphones. Is that better?
Much better.
Yeah.
Okay, so there's a problem with my headphones. I'll try that. Okay. So have you had a chance to read the legal submissions? Did you want me to go through them?
I haven't had a chance to read them, unfortunately, no. So I think it would be good if you could. I've now got to remember where I saved them this morning.
Mr. Burgoyne might be able to screen share them as well.
In fact, I'm not even sure whether I did save them. Yeah, that would be good.
I think we only got them at the start of the hearing.
Yes, you did.
Yeah, I have to find. Yeah.
I think the email was from Ashley Middleton this morning, if that helps.
Oh, that's right. Thank you.
Ah, yes, got it. Thank you.
So there's the legal submissions, and then there's also 3 consent orders, which I refer to as dealing with wastewater issues.
Great, thank you. Have you got those all okay, Commissioner Dimery?
Yes, thank you.
Yeah, good. Yeah, if you could carry on, thank you.
So these legal submissions were initially drafted in advance of the original hearing prior to the level 4 lockdown. I have amended them to address subsequent developments with the wider urban and services plan change appeals, and I've also benefited from receiving Mr. Allen's submissions on the 21st of October. I had initially been asked by the District Council to present legal submissions with respect to 3 issues, which was an update on the plan change appeals, issues around wastewater, and a trade competition. And I've subsequently added a 4th matter to that list, which is the scope to amend the zoning on the eastern part of the land to incorporate the COM and the GRZ. I won't read through paragraph 5. This was the panel's minute asking for submissions on the issue of scope to amend NAV and urban form and development. So we can skip through that. Just noting at paragraph 6 that I do address in this next section about the status of plan changes, those questions around NAV and UFD. So at paragraph 7, the Council's response to PC 150 has generally been one of leaving matters to the district-wide chapters, unless there is a site-specific reason why that is not the most efficient and effective option in this context. The table below provides an update on all of the appeals, and that was updated as at yesterday. So moving down through that table, the appeals were dealt with on a top-down basis by Judge Smith. So the strategic chapters were dealt with more prior to the more site-specific chapters. So in the top row, the DGD, District Growth and Development, and UFD, Urban Form and Development, the consent order for those was 18th of January 2021. And the Strategic Policy chapter for Regionally Significant Infrastructure, which is also in the DGD chapter, that was the 18th of March 2021. In the right-hand box there in terms of status, there are no outstanding appeals on those chapters, but they contain only policy content. So there are no rules in those chapters which can be treated as operative under section 86F. They are issue, objective and policy chapters. The next entry is for the transport chapter, TRA. So that was dealt with in two subtopics. There were rail setbacks, which are mapped in the Whangarei city, and then all of the other transport rules were dealt with in a separate consent document. All of those rules are now treated as operative, with a footnote, which is that the rail and road noise and vibration settings are actually appealed against the transport chapter, not the NAV chapter. So I deal with that later, but all of the consent order documents have gone through. All of the rules in those chapters are now treated as operative in the sense that everything that's in there is settled. The only question is whether any new content will be added. So district-wide subdivision and services topic, this was the subdivision chapter and the three waters chapter. There were consent orders for that, and there are now no outstanding appeals on sub or TWM, and all of those rules are treated as operative. And then finally, the Kāinga Ora consent order that has been referred to dealt with the business and residential zones. And so there were consent documents for the shopping centre zone and the mixed use zone in March 2021. And then all of the rest of them followed on the 26th of August. So that was the consent order that everyone was waiting for when the original hearing date was proceeding. There are now no outstanding appeals on any of the business or residential chapters, and all of those rules are treated as operative. So the next table then summarises what's outstanding. So that's what's been resolved. In terms of what's outstanding, we have two site-specific. The first is for Port Nico, which is the Port Nico development area, and that is the former Port Whangarei near the CBD in the city. There are amendments sought to that chapter for effectively the site-specific solution for that area of the city. The next court reporting date is the end of this month, and the parties are very close now to resolving everything for that chapter. There is a district-wide appeal for Kodi Dieback. The Director General of Conservation has an appeal. The chapter that is involved is the Earth chapter, and they're seeking new content to manage Kodi Dieback. So currently there is subdivision provision, but not land use provision. So that's what the appeal is seeking. And the hearing for that is the last week of January, first week of February. So we're about to go into evidence exchange for that one. Then there is the site-specific port noise topic for Northport, where they are seeking new rules. There are existing rules for the port for port noise in the NAV chapter, and Northport are seeking more generous rules and new reverse sensitivity controls on the communities in Reticulated and Marsden. The Environment Court hearing has just this morning been amended dates, but it is taking place on Thursday and Friday next week. And then the last batch is the appeals by Waka Kotahi and Kiwi Rail. The topic is called district-wide noise. The provisions sought are to manage noise and vibration within 100 metres of the state highway and rail corridors. Mediation is ongoing. The next report is due the 10th of December, and there won't be a substantive resolution of that topic either by mediation or by setting down for a hearing until next year. So it's moving, but there's more data being produced. So in terms of looping back to the question that you asked, which was the legal framework and the ability to, for the plan change, to seek changes to the NAV and UFD chapters, at paragraph 10, I have annexed the statutory provisions that are relevant, but the reason I've annexed them, I moved them once I concluded that actually they don't help to answer your question. So at paragraph 11, section 43AA, which includes many of the defined terms that you've pointed to, was inserted into the RMA in 2009 at the same time as section 86F, which deals with when rules are treated as operative. And having carefully traced all of those provisions and definitions, in my submission for this particular plan change, it doesn't matter whether a plan change can only change something that is capital O operative, or whether it can also change something that's treated as operative. The reason I say that it doesn't matter is because the NAV chapter is capital O operative and the UFD chapter doesn't contain any rules. So it can't be treated as operative because only rules can be treated as operative, not policies. So just moving down, I'll elaborate on that. If we can go down to the top of the next page. So for NAV, the NAV chapter was made operative in 2016. It was only picked up in the Urban and Services Plan Change Package as consequential amendments to zone names. There were no substantive amendments in the NAV chapter, just where the noise provisions applied. The names were updated from port environment to port zone, for example. The Northport submission and appeal seeks new port noise provisions and consequential amendments in NAV. That's part of their broader submission and appeal, which was seeking amendments to the port zone chapter. The Whakakatahi and KiwiRail submission and appeals seek those new provisions within 100 metres of the corridors. And those appeals are in a topic that is called noise. That topic is still being mediated. And given that both NAV and TRA are district-wide chapters, as a matter of plan architecture and taking into account the national planning standards, one possible outcome of mediation or hearing might be that any new content is added to NAV instead of to TRA, because it makes no difference with a district-wide chapter, it has the same application. And all I will say there is that it would not be appropriate for me to comment any further on that because we are actively mediating those solutions. So in my submission, neither the Northport appeal seeking new noise provisions in NAV, nor the Whakakatahi and KiwiRail appeals seeking new provisions in TRA make the operative NAV chapter cease to be operative. It was made operative in 2016, and if there are consequential amendments that end up being housed in that chapter rather than housed somewhere else, that doesn't make the chapter inoperative. It is an operative chapter. So the plan changes didn't propose that chapter and they didn't actually seek any amendments to it. Urban form and development is a shorter answer. It's not operative. It was proposed by these plan changes, by the Urban and Services plan changes, and it doesn't contain any rules. Only rules can be treated as operative under section 86F. But the consequential amendments that are sought are to policies. So there is a new policy about the Marsden Town Centre zone and amendments to the commercial zone and the mixed use zone policies that describe the zones to add cross references. That's because currently those two zones talk about being in proximity to the city's centre, to the Whangarei city. And so those cross references are to legitimise the use of those zones in a different location when a new town centre structure has been added to the plan or is proposed to be added to the plan. At paragraph 19, I have briefly discussed this issue with Mr. Burgoyne with respect to plan architecture, and in my submission, if you were minded to make these amendments to those policies and the scope question was the only one that was getting in your way, then my pragmatic suggestion is that the panel could recommend that the new policy about the Marsden Town Centre could be located either in the zone chapter or in the precinct. I don't think it makes any difference. From a legal perspective, it doesn't matter where it's put. The planners may have an opinion about where it's better suited. And also that the panel could recommend that the council make those changes moving that new policy and making the consequential changes to the COM and MUS policies at the next plan change opportunity. And rather than directing the council to do it, just recommend that it makes those changes, and those could be recommendations that sit in the Commissioner's decision. Did you have any questions about that first section? Because this is the one that came as a request from the panel.
No, that's been very helpful for me. Thank you.
No, same for me. It's very clear advice. Thank you.
So in terms of wastewater, originally the question that came to me in preparation for the hearing was around the issue of plan enabled, or how to deal with what the rights were from the original zone compared to what was happening in the plan change. Events have largely overtaken that, I think, and it doesn't really matter so much how it's described. The issue that everyone agrees is that there are wastewater constraints. So I've looked at it a different way, which is to see whether there are any, whether any areas in Marsden or Ruakaka have been treated differently and not had the new district-wide chapter applied to them. So at paragraph 20, an issue before the panel is the capacity for wastewater disposal in Marsden Ruakaka and whether PC 150 should be subject to the district-wide TWM provisions or customised provisions. The capacity for wastewater disposal was an issue for resolution on many of the urban and services appeals in Marsden Ruakaka. And Commissioner Dimery, I think that this may have arisen as a timing question. At the time that the council hearings were conducted on the urban and services plan change, the model for Marsden Ruakaka hadn't yet been updated. It was updated after our appeals were received, but before we started mediating them. And it brought into quite sharp relief for us that while there was capacity just for what had been already approved under the decisions, there wasn't really a lot of headroom, and we had appeals to resolve. So the council team was advised throughout by Fraser Campbell with respect to wastewater issues on those appeals. So there's been consistency on that advice. The 7 urban and services appeals in Marsden Ruakaka that progressed to resolution, i.e. that were not withdrawn, because we did have 3 that were withdrawn, were all resolved by consent order. 4 involved the use of a precinct to customise provisions, and 3 of those precincts included provisions related to wastewater. The appeals are summarised in the table below. So Keith Trustees was heavy industry to light industry, and there was no precinct and no wastewater provisions. Victory Square was the first residential one that we picked up. It went from rural production to general residential. This is by the racecourse in Ruakaka. And you will also, the tables are on different pages, but Victory Square was resolved before the Three Waters chapter was signed off by consent order. So at the time we resolved Victory Square, Three Waters was still not treated as operative. Victory Square was given precinct 9, partly because the site had a significant ecological corridor that was, I think about half of the site was devoted to an ecological corridor. And precinct 9 has a lot of ecology driven in it, but it also includes an objective, a policy and a rule for wastewater, which largely says you need to make sure there's capacity. I've included copies of these precincts. Marsden Maritime Holdings is the owner of the reserve land, the future port expansion land for Northport, and Marsden Maritime Holdings is an owner of Northport. That appeal was resolved in terms of how the port future development land was able to be, what types of activities could be able to be progressed on that land, and there was no precinct and no wastewater provisions included in that. That was more around the balance between commercial and industrial uses. Kāinga Ora is the consent order for zoning. In the Ruakaka area, there was a small amount of rezoning from general residential up to medium density residential in behind Bream Bay College in Ruakaka Centre. There were no precincts and no special wastewater provisions involved. Advanced developments is rural production land that went to light industry, but with a precinct across the top that was always intended to be a precinct for a data centre. And on the advice of Mr. Campbell, and also we asked for the appellant's engineers to be involved, the precinct for the data centre includes an objective, a policy and a rule for wastewater. It's quite prescriptive about setting a wastewater cap, and after the cap there are additional consenting requirements that chip in. That was generated by the engineers, so that came to us from the engineers as a solution for that site. That one came after the Three Waters chapter had been resolved, but there was quite a long lead time on a lot of these resolutions. The next one is the REGI, Ruakaka Economic Development Group. This one was hundreds of hectares of rural production to general residential. This is the one, Commissioner Dimery, you were referring to. Both REGI and Pile overlapped, and there was a suggestion at the council hearing stage that they could just be done by on-site wastewater disposal. There was some resistance from the council to doing that over large areas because of the difficulty of then later trying to reticulate them. So the REGI area, for a significantly smaller area than was originally sought, was given precinct 16, which is as close as you get to a future urban zone in the plan. So there is an objective, a policy and rule in there which effectively defers the upzoning until the wastewater treatment plant is upgraded. That's because it's beyond the urban edge. It would be an extension of the One Tree Point urban boundaries, and the approach the council took is that it would be unfair if that land were to be allocated a portion of the existing remaining capacity when there are other areas that were rezoned earlier or already held residential zoning that haven't been built on. So effectively the REGI land has a future urban management technique on it, which is that they cannot bring forward that development until the wastewater plant is upgraded. The significance of that is because the site area was huge and it's beyond the urban boundaries and was rural. And then the last one is Pile. There was a small area of the Pile farm on the coastal edge where the council did agree that precinct 15 could apply. There would be on-site disposal because of low density residential zoning, which is an on-site zoning, and it's for 8 allotments of 2,000 square metres each, I think is the size. So there are 8 allotments there on the coastal fringe on a family farm. And that was a relatively small area, and there is no wastewater. The solution for wastewater there was that it was on site rather than being reticulated. So in the final paragraph in this section, the next page, just paragraph 23 there, in each of the 3 appeals resulting in upzoning from rural production to an urban zone where wastewater will be reticulated, so that is Victory Square, Advance and REGI, the precinct provisions have addressed wastewater constraints. Where there were urban zones that were rezoned to another urban, so going from heavy industry to light industry, from general residential to medium density residential, there was no wastewater provided. So we used it where there was effectively a change in use. Are there any questions on that section? Because that's another big chunk.
Not for me, thank you.
No.
No, thank you.
Okay, so trade competition, this one's really quick and the rest of the submissions are quite short now. I have read Mr. Allen's submissions on this point. I've previously given consideration to this issue of trade competition because it was an issue in the Urban and Services Council hearing stage. And I have looked at it in detail and I concur with Mr. Allen that Discount Brands' line of cases draws a line between trade competition effects, which you cannot consider, and significant socio-economic effects on centres, which you can consider. So the example that's always given is if if the public amenity services such as the libraries and the post offices are going to be closed and have significant adverse effects on the elderly walkable community, that's going beyond trade competition. Those are socio-economic effects, and those are valid effects. So I concur with that conclusion, and I also agree with Mr. Allen that I think it's unlikely to be an issue now, because the amendment that had been sought to the UFD chapter to deal with a hierarchy of centres has now been withdrawn. So I don't think that the issue is a live one for you anymore. And finally was a new issue of the scope to amend the low density residential to COMZ and GRZ. And again, I've read Mr. Allen's submissions, and I've also read Mr. Badham's assessment of the yield calculations. Yield calculations are a way in which the council has previously dealt with consent documents for Judge Smith in the rural plan changes, which came 3 years before the urban and services plan changes, where we had quite limited scope under the submission because it had asked for a specific zone outcome, but the planners had agreed that the best defensible zone planning outcome was something that was slightly different. Yield calculations were used in the consent documents as part of a Section 32 analysis and put to His Honour as part of the consent documents process. And in the 2 appeals where we used the yield calculations, he accepted that that was a valid methodology for working through scope questions. So I agree with Mr. Allen's submissions that scope for the amendment from low density to COMZ is in the Wakakotahi and the Northport submissions. I agree that they asked to remove that residential component adjacent to the state highway. And consequential upon that amendment, the zoning of what I call the island of low density residential land then needed to be addressed and a defensible zone boundary considered. And I agree that the submissions that were identified in Mr. Allen's footnote 8 support residential zoning for PC 150. And in the last paragraph, which is the end of my submissions, as the council's advisor on the urban and services plan changes and on this private plan change, I don't have any scope concerns about that change from low density residential to a combination of COMZ and GRC. It's something that I have taken myself into those submissions. I asked for the submissions and went through them, and I think the yield comparison is also helpful, and I don't have concerns that there is any out of scope relief being proposed.
Good, thank you. Commissioner Dimmery, do you have any questions on that last piece at all, or any other questions from Ms. Shaw?
No, thank you. That was of assistance. Thank you.
No, thank you from me. That was really helpful and very easy to follow. So thanks.
Thank you.
So I think I'm correct in saying that brings it to us to the end of what we were expecting to get through this afternoon. Perhaps a little bit later than we expected to be, but I think we're now there. I wonder whether has anyone got anything they wish to raise regarding tomorrow, or any procedural issues before we adjourn for the evening? Nothing from no one. It's very hard to read the faces when you're on this. Okay, so we're now adjourned until tomorrow morning, and we've agreed, I think, speaking with Mr. Burgoyne, that Kiwi Rail have asked whether we can start at 8:45 a.m. rather than 9 a.m. So that they can then have 45 minutes rather than about 45 minutes, I think. So yes, we're adjourned until 8:45 tomorrow morning. Thank you. Has everyone heard me? Because my screen is frozen.
Yes, I heard.
Yep. Thanks
Yeah,
very much.
good. Okay, some parts